Alrighty, good morning everyone. We will go ahead and get started. I hope your extra break rejuvenated you for a very exciting conversation. Thank you all for sticking with us. I know being between you and the lunch hour is a little bit challenging, but I promise you will be deeply rewarded with a great program. My name is Tamara Nash. I have the great joy of serving as the Young Lawyers Division Chair-elect. And today we have a very exciting program for you. Our panelists rather, are going to highlight a very necessary conversation, specifically America's response to the pandemic. They are going to dig into how the response to the pandemic magnified the existing inequalities and illuminated the interconnectivity of race, health, wealth, and justice in our nation. We have a few objectives we are going to strive to accomplish for you here today, and those are going to be to examine the ways in which the pandemic has impacted the most vulnerable in our nation and magnified inequalities in our justice system, to also address the pandemic's impact on United States Supreme Court doctrine on public safety, health, and civil rights, to explore the impact of courts moving online, particularly in the criminal justice system, and lastly, and importantly, answer the question, where the heck do we go from here? So, as you can tell, pretty lofty conversation, so we're going to dig right into it. Joining me for today's conversation are three fantastic panelists. Really excited for you all to hear from them. I'm going to take a moment to highlight some of their bios, but I encourage you to go online to learn more about them. First, I'm going to start with our middle panelist, Wendy Mariner. Wendy serves as a professor emerita of health law, ethics, human rights at Boston University School of Law. Wendy's research and teaching focuses on voting rights and fair elections, risk regulation, health law, public health, health insurance, and the Affordable Care Act, and health information privacy. She is the author of public health law textbook and more than 100 articles in the legal and health policy literature realm. And she has a wealth of bar service within the American Bar Association, including service as a current section delegate to the ABA House of Delegates from the ABA section of Civil Rights and Social Justice. And she is a member of the ABA Standing Committee on Disaster Response and Preparedness, a member of the Health Law section, and is a Life Fellow of the American Bar Foundation. And she is also a past chair of the Civil Rights and Social Justice section.
And she's mortified.
And she was also a member of the ABA Task Force on Legal Issues arising out of the 2020 coronavirus pandemic. So as you can tell, we have a wealth of knowledge and expertise coming from Wendy today. Next, to my left, we have Stephen Stapleton. Stephen is an attorney at Clark Hill PLC in Grand Rapids, Michigan. He has an extensive expertise in commercial litigation, including complex breach of contract claims, business disputes, municipal litigation, condemnation actions, and employment litigation. He has tried cases before state and federal courts and successfully argued before the U.S. Court of Appeals and both the Michigan Court of Appeals and the Michigan Supreme Court. He represents clients in arbitrations and other forms of alternative dispute resolution, and he is also the immediate past chair of the ABA section of state and local government. And last but certainly not least, we have Malia Brink. Malia has spent more than 20 years working in criminal justice research and reform advocacy. She currently serves as senior policy attorney at the Deason Criminal Justice Reform Center at SMU Law School. And prior to joining the center, Malia served as counsel for the Indigent Defense to the ABA Standing Committee on Legal Aid and Indigent Defense Center. I have a word missing here, so you feel free to correct us. Awesome. Was going on a whim here. And while at the ABA, Brink served as Deputy Director for the ABA Standing Committee on Legal Aid and Indigent Defense, Public Defender, Work Alert Study Projects, and the Misdemeanor Court Observation Projects. And she also has prior service in academia and is also bringing us a wealth of knowledge today. So as you can see, we have 3 awesome panelists. So as we start our program, we took some time, or I should say, as we were planning the program, we took some time to figure out how the heck are we going to cover such a vast conversation and present it to you all in, bite sizes where you're like, okay, what the heck are we talking about? And to, something that you would enjoy talking about. So what we landed on is that each of our panelists are going to take some time to give the lay of the land as they see it and providing the observations that they have made to date from the pandemic. That's of course informed by their expertise and their areas of practice. As they saw things happening, the folks that they saw being impacted more specifically. And then once we get that lay of the land, we're going to take a loop back and then we're going to see maybe what are some of the overlaps that our panelists saw in the nation and our response to the pandemic. So that's our starter course that we're going to have, and then we're going to go back in and fill in the gaps. So first up to bat, Stephen, you want to kick us off here?
Sure.
Awesome.
Thank you. Good morning, almost afternoon. I'm on the Eastern time still, so it's like 2 o'clock for me. I am going to get into a little bit sports-oriented with respect to COVID. I'm going to give you a little bit more of the real time from a lawyer, what was happening in March of 2020, and then kind of what we saw. You'll see some slides later from some of the other presenters that are excellent, I think, especially for a young lawyer, as some of you maybe only know of the Zoom virtual format for the last few years. So I like to find out a little bit, we're here, Saturday morning, a little bit about folks. Who was entering law school when your law school was shut down? Like you were starting your first year of law school remotely. Do we have anybody here that was doing that? Yeah, I just can't even imagine what you did. I went to law school 30 years ago, 25. But not having that social one-on-one interaction for your first year classes, I think that's phenomenal that you're going to graduate. You're probably third year right now, yep. So congratulations, based on what I saw. So as indicated, I'm the immediate past chair of the state and local government section, which is the best position to have in any organization. I saw the presentation before, and I'm trying to get in there, and I've been a part of the state and local government section for many years, since I was in law school, as a matter of fact, and worked my way up, and last year became the chair. I was finally glad, and they're like, it's COVID and everything's shut down, so there's going to be a huge budget deficit, and you'll go down as probably the most financially, worst chair that you've ever had, but it was a good year, and we tried to make the best of it, which I think you'll see all of us have done the last couple of years. As indicated, I'm with Clark Hill. We're a international law firm. I'm based out of the Grand Rapids office. I'm in the litigation practice group. I'm also the chair of the sports industries group that we have, and I'll speak a little bit about that because what we see in life, in reality, sports and the sports organizations, we're the ones that were the leaders in shutting down the economy. We'll go back in time a little bit, and you'll see you guys will start to remember that. The only other caution I have for you, I know some of you are probably listening to college football games in your earpiece. So you're probably not clapping for anything that we're saying if there's a touchdown. My daughter's fiance is playing right now for Wisconsin, the Badgers, so it's killing me to not know what's going on. I get texts from her when he gives up a sack or does something else. So, But I think it's important, especially for the young lawyers, and for me, I've been practicing 27 years, to kind of understand when March of 2020 came, and actually a lot was going on in February, there was no book that lawyers could look at. There was no resource, essentially, that we could go to say, how do we deal with a novel coronavirus that's coming around? There wasn't much research or books that were in print from the 1918 pandemic. You couldn't Google it. I mean, you could try to Google as much as you could. But I'll give you, now that some time has passed and I can state some of this publicly, some of it was not able to be publicized. But as part of my work, as I indicated, I represent a lot of athletic-related institutions, coaches, athletic departments. We do Title IX investigations, represent coaches in disciplinary proceedings and some of their other endeavors when they're changing jobs. So late February 2020, we all knew something was happening. People are telling us something's coming. There's a few cases that are in the United States. Nobody really knows what's going on. People are on TV telling us, there's not a significant risk to the United States. As a lawyer, as a litigator, I'm traveling all around the country. You're on airplanes. You can start to see as February's going on. You're in the terminals. You're having beers. You're doing whatever. And then you start to see the people distancing themselves as you get through February. This is before the spread. February 28th, I'm in New Rochelle, New York. We know something's going on. We're in a meeting, pretty private, confidential meeting, in a diner with the president of a university negotiating a contract for a basketball coach. That basketball coach was Rick Pitino, who's now at Iona College, so I can say that publicly. But we're in the diner, and we're making sure we're staying away from everybody because we don't want people to hear what we're saying and because we don't want whatever anybody might have. So I fly home that night, get home over the weekend. I think it was March 3rd. The TV's reporting that there's an attorney from New Rochelle that tested positive, and he's in the hospital for COVID. And they're starting to create a quarantine zone in New Rochelle, for those of you who might remember. And I am telling my wife, who is this lawyer? Like, I need to know who the lawyer is. As if that was the lawyer that was in our meeting, right? What's the chances of that? So I'm trying to call around, was this lawyer in a meeting with us on Iona College? They say no. So we find out who it was, and then you start to see how scared everybody's getting. But you might want to, the mere fact that you were in New Rochelle, you might want to just kind of stay away from people for the next 10 to 14 days. Remember that? They told us that. And then see what happens. March 11th is the key date for us lawyers, I think. March 11th, 2020, there was an NBA game. Utah Jazz and Oklahoma City Thunder. Rudy Gobert tests positive right before the game. The fans are in the stands. Game's ready to start soon. Rudy tests positive for COVID. They announce that the game is. They just go right out to the intercom, announce the game's been postponed until further notice. Please leave. The NBA then, within moments, issues a public statement that says all games are canceled until further notice, so they can determine what steps to do, next steps for the novel coronavirus. March 16th, everybody knows that date. That was 15 days to slow the spread was announced. So essentially that, for us lawyers, the event of the NBA game on March 11th, that put a lot of us that deal with it, certainly everybody in the world, but lawyers that deal with K through 12 districts, universities, sports entities, that changed the way we do everything. I literally went from handling whatever I was handling, doing routine discovery requests, to then shutting universities down. My daughter's fiance, who plays for Wisconsin, to show you what it was like at that, they said, hey, we're going to go home, leave your stuff here. We expect to be back in 15 days. So all those football players leave their dorms or where they're living. They didn't even take much with them. They go home. He comes home. 15 days turns into months. Never reports back to campus. Doesn't even have all his clothes. They had just come back from a bowl game. They had all their free bowl game merchandise worth thousands of dollars in their dorms. So they were hoping that didn't get picked over when they went back to move out. But that's how quick it was. So as lawyers, right then and there, from the real time, we were pausing activities, we were canceling activities, we were reviewing contracts. Law school folks in here, and we'll get into this in the questions, force majeure. I can tell you as a lawyer for 25 years at that point, I had dealt with force majeure, I don't even know, maybe twice. I see Michael Camprath back there is with the Tampa airport. I'll bet you he dealt with force majeure as well. But I remember that term in law school, but then it was our favorite term for like months. And for young lawyers and anybody that goes into the profession, I'll tell you this. I reviewed so many contracts, some of which I may have had assistance in preparing, that the force majeure clauses were not that good. You know, when you go through those contracts and you see those last 10 or 15 paragraphs that are all just boilerplate stuff and what law applies, choice of law, force majeure, just pay attention to those because you never know when it's going to cause. It would be so you could look like the best lawyer in the world if you had the appropriate provisions in there or something financially significant can happen to your client. So the other thing we spent doing, we were interpreting state laws, federal laws, local laws, and restrictions and executive orders and directives from all the various governments on restrictions being placed on all of our clients. And we're trying to, and the young lawyers in our office and the summer associates that stuck around that we had to call back up and say, hey, can you help us? They were just invaluable. They were going out, getting all those, summarizing them, getting them out to the clients so that we could let them know what's going on. And, you know, as no surprise to all of you, those directives that were coming from the federal government, state governments, from the local governments and the health agencies, they always weren't consistent. They were, in fact, inconsistent with each other on numerous occasions. They also, had terms in them that weren't defined, so then the lawyers have to tell their clients, what do you think those mean? And then we're telling our clients what those mean. And then maybe the governor agrees with us. I got a call from the governor's office in one of the states. I don't agree with your interpretation. I'm like, well, then define the term. We have to operate in real time. So define the term. What's a face covering? What's a facial covering? Remember that? We didn't know how do you wear one of those? So those were some of the things we were dealing with. And I just wanted to cover that a little bit. But the inequities. I was also a former school board member years ago. So as lawyers, I saw a panel yesterday. It was a great question and answer on a particular thing. I think it was to the judges on the judges panel. When we handle things, and the judges have to be, as impartial as they possibly can. But as lawyers, we have to represent our clients. Obviously, we have those obligations, ethical obligations, but we also see what's happening. So it's not unlike during that pandemic, superintendents are calling us, athletic directors, presidents of university, and so on. And we're being called in to look at things. And we did see things that we'll talk about later that were concerning. So forget about us being a lawyer, us having to go virtual. Most of us can do it. We can figure out how to do it. But some of those inequities that we did see, and as a former school board member, it killed me to watch some of it. The district my children attended was a pretty diverse district economically for sure. And so it would be what's called, I think, a Title I district. About 40% of their kids were Title I, which means that for them, breakfast and lunch, that's where they got their meals. So the kids, when my kids are growing up, they realize, why aren't we having snow days in Michigan? We're not. This weather's really bad. I remember on the school board, we didn't like to close for snow because those kids couldn't get their meals. So if we could get them to school safely, they were coming to school so they could get breakfast and lunch at least. So we did see some inequities, and I'll kind of finish my presentation to show you a little bit of what I saw. The number one right off the bat when they were going remote and virtual, obviously the most places in the United States, they weren't ready for that. So we saw children with no devices or limited devices, inadequate devices. The other one, which we'll talk about, I still think is happening today, and that's just my personal opinion, is what we saw was the limited internet Wi-Fi capabilities. And we saw children making way the best they could to try the ones that they loved school, wanted to get to school, and they couldn't hook up because wherever they lived, and they couldn't afford it, didn't have it, the connections were bad. State and local government section, you think of the tribal reservations too. I mean, the things the inequities there that are built in there, that shouldn't be that way. So somebody said to me the other night that I thought was good, Wi-Fi should almost be a public utility, and we should think of it. And so if the pandemic has taught us anything, we'll talk about that later, there's some things that we should realize that it's a public utility. No satisfactory infrastructure in place for the food or meal program. I had partners in our firm and associates being called to try to figure out how to get that infrastructure in place, reviewing agreements, getting people together to make sure that those children had their food and meals for a very long time, by the way, and even through the summer. We could talk about the mental health aspects of it later, but that certainly was something that we saw both from the staff. I saw teachers K through 12 that were, just wonderful, working really hard, far more than they were, getting paid, I'm sure. And they should have been paid a lot more for the work that they were doing. But we saw it. We saw the students with disabilities, special education students, where that was removed from them and they were then at home. Childcare and caregiving still to this day is still an issue. So we saw that as lawyers. It's very difficult to watch that, but again, we try to make it as good as we can based on the circumstances that we have to deal with and advise our clients. In the sports world, I'll just finish with this. We saw what I would call constant disruptions. You saw the extracurricular activities in the sports world shutting down, starting up, shutting down, pausing. So lawyers were always involved in those processes from our firm, trying to create guidelines, return to play protocols, what's going to happen if somebody gets it, how do we deal with it, how can we continue to play. And then in the inequities in that particular instance, what we would see is, I do a lot of work in the hockey context, in the hockey world as well. You get a call from a local municipality or school district, hey, there's some people playing in the hockey rink while everything's shut down. Well, that's because probably they can, and they figured they weren't going to get in trouble, and they had the economic means to do that, sneak in the back door and play hockey during the COVID. And then you had basketball courts. There's pictures of them where they're taking the hoops off, and they're taking the bat, so people can't play. And usually in those neighborhoods, those kids needed some outlet to play, and now it seems kind of silly. But I can recall it. I went to a school well into the pandemic, and the basketball hoops were down. And, you just think, put the hoops back up. Just let them get some activity down there. Let them wear their masks, which is what we would do, and some of the school districts put into play. So that's some of the real-time things we saw. We'll talk about it. There's some really important slides you're going to see in just a little bit. I'm happy to be here, happy to answer questions. I think the young lawyers here, as you start your career, you're going to have really good opportunities with what's going on. Somebody in this room that's a lot smarter than me, if you write a book on the pandemic and maybe best practices, so in 100 years when there's another one, somebody will have a book to look at, because we did look for them. Thank you.
Absolutely. Wonderful. Thank you, Steve. All right. Let's move down the line. Wendy, do you want to take a stab at outlining the observations you've made, those you find to be most impacted, and kind of give us the lay of the land as you see it?
Yeah, thank you, Tamara. It's okay. All right. Yes, can you hear me? No. Is it on?
Just pull it off.
You want to pull it off
Yeah.
there?
Yeah.
Or move
Just
it
pull
along
off
the
stand
side,
and hold it
Wendy.
in front of you.
Here.
We can just, do you want to just pull it off the stand?
No,
Okay.
because then I can't.
Fair enough.
How's that? That's a little better. Okay. Great to be here. Beautiful city, and yeah, it's my job to take us up to a 35,000-foot level, away from the reality of practicing law, and depress you all by talking about COVID and disasters in the Supreme Court, because the pandemic offered some opportunities for some rather opportunistic litigation much of which landed at the Supreme Court level, and enabled the majority of the Supreme Court to modify constitutional doctrine in ways that I think have long-term negative effects on public safety and health and civil rights.
She's saying lead in even more. I'm sorry.
Okay. That doesn't pull. Okay. So I've been thinking a lot about emergencies for quite a few years and worrying, the way we used to, that emergencies can justify exceptions to the rule of law, right? And long-term emergencies can heave long-term changes to the rule of law. And we used to worry for decades that an overly ambitious, coercive government would use emergencies to make long-term restrictions on civil rights, which we have seen. But now we also need to worry about powerful politicians and economic interests that use emergencies to deprive government of the power to protect our health and safety and civil liberties. And that is what I think has been happening in COVID, some of which early on. How many of you know about the social determinants of health? A few, right? So this is my thing. Well, it's not mine, obviously, alone. But I mean, the social determinants of health are those factors: education, income, employment, environment, neighborhood, education, that enable people to live well and stay reasonably healthy, or at least protect themselves or respond well if they have risks to health. And at the bottom, this is what creates the infrastructure, right? Our educational infrastructure, our social infrastructure, our physical infrastructure, our financial infrastructure, how we can get a mortgage, who can get a mortgage, what the rents are, what the protections are, what environmental protections are, et cetera, et cetera, et cetera. And the bottom of that infrastructure is law. So I would argue that law is the fundamental determinant of health, as well as many other things. And that is what is worrying me about the decisions that the Supreme Court has been making. If you look at it from a liberty perspective, what about the liberty of children, right, to get an education, a quality education? What about the liberty of children not to get gunned down in school? What about the liberty of workers not to get COVID when they have to go to work? The list goes on, and all of a sudden we have to flip our perspective to sort of, okay, who in fact is protecting us from these threats? Well, it's often government, and now the power of government is under threat, and the Supreme Court decisions over the last couple of years, particularly during COVID and certainly this past year, have threatened that in two ways. It has obviously privileged a couple of constitutional rights, religion and free speech, and gun ownership. And it has downgraded other kinds of civil liberties, those that are not as easily mentioned, everything from contraception to education to abortion to same-sex marriage, interracial marriage, and the like, all of which are now being threatened. And I could give you a couple of examples. The trend, first in religion and second in substantive due process. So the Supreme Court sort of indicated its privileging of the free exercise of religion in several COVID cases, many per curiam, often in cases in which those objecting to either restrictions on worship services or closures of not so much businesses, but of religious worship services, who brought emergency injunction claims. And cases sort of went right down the line. There was, now, I did need a slide here to list all these cases, but I probably won't get it. In the Roman Catholic Diocese, which was the New York decision in November of 2020. That was a per curiam decision, again, privileging free exercise of religion over any kinds of restrictions. And the same thing happened in South Bay Pentecostal against Newsom in California in February of 2021, Tandon against Newsom in April of 2021. And these all I think, expanded the scope of strict scrutiny for free exercise claims under the Constitution. And I think Tandon really solidified it in a case about Governor Newsom's restrictions on gatherings for religious worship. Tandon said that government regulations, and I quote, trigger strict scrutiny whenever they treat any comparable secular activity more favorably than religious exercise. And any was italicized in the original. There are a lot of critics of this approach, particularly when the Supreme Court based its decisions on what one could call alternative facts, which is a little troubling if the Supreme Court is actually going to make factual determinations. It compared going to church or a synagogue and spending hours singing, preaching, with running in and out of a hardware store. That was the comparability. So once you change the doctrine to determine what is comparable to anything that suits the justice's ideas, and then you couple that with the notion that the justices were essentially making factual determinations. So what happened to appellate review limitations? What happened to rules of evidence? And then to top it off, the question is, well, what counts as a religious belief? And we have no standard for that from the Supreme Court. As long as your belief is sincere, it appears to be something that the Supreme Court will consider as qualifying under the Free Exercise Clause. So if I believe that if I take a COVID vaccine, it will change my DNA and make me magnetic, people have argued this. My religion or my deity says that I am immune and I no longer need to take vaccines or wear a mask in my employment or whatever my employment. Is that okay? And if that's true, it's not just COVID. It's mumps, rubella, measles, polio, whooping cough, monkeypox. If it's a constitutional principle, it applies well beyond a disaster.
Tetanus,
Yes,
which is hideous.
they're all hideous. And that has continued, over the next several cases. We now seem to have a free exercise clause, but not an establishment clause any longer. There's selective use of the First Amendment with the short-lived case in my own city of Boston, in which the city refused to fly a flag of a Christian organization for fear of violating the Establishment Clause. And the Supreme Court said, no. That is refusing to fly that flag when you've flown other kinds of civic flags is a violation of the First Amendment free speech requirement, because you have not limited this as government speech, which is true. They didn't have a really good policy, and now they will have a good policy. But it is an exercise of private speech, and therefore you cannot discriminate against religion in allowing what flags fly at City Hall in Boston. Then, of course, there's the Bremerton case of the football coach who prayed in the middle of the field right after the game, in which the Supreme Court said this was a private personal activity. It was in the middle of the field, at the end of a game, in a public school, on a public field, with everybody visible and encouraging the players to come pray. But of course they didn't have to. And of course no athlete would feel intimidated by a coach who says, come pray with me. or you may not get any playing time, and you may not get that scholarship to college, and you may not get anything else. Justice Sotomayor was sufficiently upset. She included photos in her opinion, published opinion, of him in the middle of the field. Really? I mean, you have to go that far to object to, again, the factual questions. So I'm mindful of time here. The second example that I would alert you to, which I'm sure you're all familiar with, is the sequela from the Dobbs against Jackson Women's Health, in which substantive due process is now at issue. And not just abortion, but not just contraception, not just same-sex marriage, not just interracial marriage, but the entire substance of what we call the substantive due process clause. And this also came up earlier in the COVID decisions. And in a case where, I have the quotes, here we are. In July in 2020, Justice Kavanaugh, in the Calvary Chapel case, which was a religious objection case, pointed out in his concurrence that courts should be extremely deferential to states when considering a substantive due process claim by a secular business, which of course he described also as abortion clinics, where he didn't actually have to, because the abortion cases didn't go to the Supreme Court, they split on COVID. But courts should be extremely differential when considering substantive due process claim by a secular business that is being treated worse than another business. But he said there are certain constitutional red lines that a state may not cross, even in a crisis. Those red lines include racial discrimination, religious discrimination, and content-based suppression of speech. Everything else is up for grabs, and as Alito made clear in his Dobbs decision, that means the rational basis test, and an extremely differential rational basis test. And to the extent that his opinion set forth a principle for determining what is covered and protected by the Due Process Clause in the Constitution, it seems that most of the rights that we care about, from education to making medical decisions, would not be covered because they are not deeply rooted in our nation's history or implicit in a notion of ordered liberty. So when you think about what things we rely on that are not in the text of the Constitution, are not necessarily deeply rooted in our nation's history and tradition, and are not implicit in in ordered liberty. I would think a lot of things are, but the court clearly is not. I think that throws open a vast array of rights that we depend on, and rights that we may consider to be more affirmative, a more affirmative form of demanding government protection to enable us to have education, to enable us to have housing, to enable us to live in neighborhoods where we aren't afraid, to enable us to live in areas where we are not exposed to toxic waste, to enable us to get jobs that aren't dangerous and threatening, to enable us to get an income that we can live on. All of these things are essential, not just to daily life, but also to disasters, because I think, as we all know, disasters always hurt the most disadvantaged parts of the population worst. And the best way to prepare for a disaster is to have in place that infrastructure, from income to neighborhood to environment to education to access to health care, that keeps the population resilient, enables them to withstand and survive a disaster. The same kinds of things that enable them to live a decent and dignified life. So that's the connection I make between the abstractions that are swirling at the level of the Supreme Court, who is issuing opinions that are highly formalistic, totally divorced from reality, as they are proud to say, because they don't want to be influenced. I don't know which is worse. Robert saying he doesn't understand why the public is questioning the Supreme Court's legitimacy, or that he really doesn't understand, or that he does understand and won't do anything about it. It is, I think, a very dangerous time for people in the law, but it's also an opportunity to get out there and make sure that there are laws in place, regardless of what the Supreme Court may define as constitutionally protected, that do protect the population all the time, in normal times and in disasters, because disasters will increase given the climate situation that we are in. So thank you.
Wonderful. Thank you, Wendy. And I did just want to take a moment and highlight Wendy graciously provided an outline to her materials, which do reference all the cases that she just noted. So if you're like me, feverishly writing down things and miss them, no worries. They are in the outline that she did provide you all. So just wanted to give that plug before I forgot at the end of the program. So with that, Malia, you are our anchor. Do you want to bring us home with your observations and highlights?
Sure, and I'm wherever she is. Allie does not need to worry about me. I can be very loud. So I want to. We heard about advice, and then we went up to the 30,000 foot view and kind of what is law coming out of the pandemic. And I want to take us right down to the lowest level of what's actually in courtrooms during the pandemic. And I come to this in a very particular way. I was working at the National Association of Criminal Defense Lawyers, working on public defense reform prior to Katrina. And at the time that Katrina hit in 2005, I had 2 class actions pending in Louisiana against the state of Louisiana for failure to provide adequate public defense. When our clients who are in jail or in prison have no control over whether they evacuate. And in fact, during Katrina, despite a mandatory evacuation order, Plaquemine Parish, which is a county, they call them parishes in Louisiana, Plaquemine Parish evacuated their prisoners to Orleans. And all of the prisoners were still in Orleans Parish Prison when Katrina came through. After 36 hours in a jail flooded and without water and with overflowing toilets and without food, they were evacuated to an overpass, put randomly on buses, and sent to prisons across Louisiana. After a brief stopover for many of them at a field in a facility called Hunt, where they were just kind of all put in the yard for 12 hours overnight, and then back on buses to all the parishes that had open spaces, including a not yet open Supermax facility in Bossier, so like an empty random prison. And about 48 hours after Katrina, I flew into Louisiana to start interviewing evacuated prisoners just so we could figure out who was where, because in a parish-by-parish system, the public defenders in New Orleans had scattered to the high winds. I mean, they were all over the country. Nobody knew whether there were going to be files. Nobody knew where these people were, when they were going to have cases. And I will say that the worst case scenario is something we have experienced, which is just the courts shut down. They stop operations. So when you hear that everything is shutting down for the COVID-19 pandemic, my mind immediately goes to, what are we doing about the courts, particularly people who are detained with pending criminal cases? So that's what I want to talk about. I want to talk about pandemics, court, and particularly criminal court. So we went from that, right, to this. And I intentionally sized them differently because the reality is they're sized differently. We're all here in person. You are much bigger than if I were looking at you on a Zoom screen, as am I. That is a significant difference. It is better than nothing, so I want to start there. That's very good. I want to say that this is actually a very optimistic view of Zoom court.
Yeah.
I love this Zoom picture because most people are lit. There's actually one person who's a little dark. Most people are lit. They are all well-centered and well-focused on their face, right? That is not the reality. But as you consider what it means to go from the right side picture to the left side picture, you have a lot of, I mean, as a criminal defense lawyer, they talked about SCLADE, right? So I'm automatically coming at this from the perspective of poor people who are either charged with crime or seeking legal aid assistance for critical civil matters. What does it mean to move from in-person court to Zoom court? And there are a lot of barriers to virtual court, right? One of them is just access. I don't actually have the map. If you overlay the map of poverty in America with internet access in America, you will find they look almost identical. And so one of them is about technology, but I want to really focus in on comfort with technology and how that plays into perceptions. Because your ability to use this, if it's used in your daily life, we are often, like, I don't know, I'm on Zoom 6 times a day. I'm pretty good at it. But if you are showing up to Zoom as the exception to your daily life, as a kind of regular pandemic worker, like a supermarket clerk, somebody who works at Starbucks, it is not your daily life. And the difference in perception between all these lovely people who will teach you how to look better on Zoom is huge when it comes to courts and outcomes. Background, angle, surroundings, right? You've probably all learned how to do it for yourself. Make sure you look good. We all raise the computer, right? Just like we do with selfies. We all learned it. Our clients have not. And our ability to teach it to them for that court hearing is really problematic. It gets even worse when your client is incarcerated. And I very intentionally backed my incarcerated client up because even before the pandemic, when we went to virtual court appearances for things like bail, what happens is they put the camera, to protect the camera's on the wall in the corner. And what I am doing, if you're lucky and your lawyer, your public defender is in the same room, is I am standing at a podium with my client who is, got shackles on his wrists, in an orange jumpsuit standing next to me. And the difference between how you view and deal with a client who is in a lovely suit and smiling and sitting next to me, Wendy is my client, let's do Wendy as my client, right? Versus this person is my client, it has a real impact on how courts operate. And this is often the reality of pandemic court, right? We've all experienced this. We're all experiencing Zoom fatigue. And we go from, now it's not just people, it's like just boxes with names. I also want to point out, before we move on, that one of the really hard things is a lot of our understanding and experience, particularly our clients' experience of court, is spatial. How do you identify who is the judge? How do you identify who is the prosecutor? How do you identify who is your defense lawyer? Right? A lot of it is spatial. You come, you stand next to me, I'm your defense lawyer. This person on the other side is the prosecutor. Maybe the victim is there as well. The judge is the person on the stand. Zoom doesn't give you any of that. And it makes it very confusing, particularly in a court call where, again, public defense, most of the time you're dealing with a bunch of clients and other people behind you who are not relevant to the immediate proceeding, and only the people who are relevant or pulled forward. In Zoom court, more often, I don't know if you've ever joined a Zoom court call, right? But it can be 50 people and everybody becomes really tiny little boxes. And just trying to keep the judge pinned. Teaching your client how to pin a judge is one of the worst experiences you will ever go through. Just as an FYI, trying to teach that is a nightmare. So what is it doing? It's really breaking down attorney-client relationships. The early part of the pandemic, a lot of public defenders were not allowed in jails. Many of them didn't want to be there. I understand that. It wasn't safe. Like, the last place you wanted to go was to a jail, right? Voluntarily enter a jail? No, thank you. But our ability to ask questions of our clients, establish that trust. Everybody in here who has a lot of Zoom, right? Your ability to Zoom effectively, to transition from in-person to Zoom effectively, is much higher, I bet, with people you knew from before, people you have experience of, people who you can read. But if it's a new person, it's hard to get that foundational level of trust. And so one of the best things I heard a lawyer say, it's up there as a quote, you have to earn the trust to go virtual. I would add the word effectively, because we do it all the time, but to do it effectively, you have to earn trust first. The other things I want to point out about virtual court access, family and friend access, right? In the criminal context, very important, right? Whether somebody is anchored in the community, has family support, it's a visual cue that they have people behind them who are going to help them and a place to go. And we don't have those visual cues on Zoom Court. Oftentimes, if there is public access, and that's the only kind of access family and friends are now entitled to, it's a kind of visual only, it's a YouTube feed. And so the judge will never know who's there for that person. And that is incredibly difficult. At the same time, while courts are public access, nobody was recording them and putting them online. And you're not supposed to, right? Though a lot of them have the little warning, do not record, but there's nothing that can prevent you from doing it. And even if you were on a platform that could prevent it, like you can't hit record on Zoom without it announcing to everyone, this is now being recorded by a participant, right? We've all heard that. There's nothing that stops you from holding your phone in front of the screen. And so at the same time, privacy access is a big deal. Also, yesterday I had to run out of a session here because I got an email that my office was holding a virtual event and that somebody had shown up and pornography bombed the event, which I hadn't heard of in about a year, so that was kind of new and interesting. And there were measures, like there was registration and a waiting room and the whole thing, and it still happened. Right? What is it like if that happens and you have to reconvene court? There have been recent studies on the impact, right? Prior to the pandemic, we really did not have a lot of good studies on what remote access does in courts. These are really, the studies that are coming out now are largely like self-reported. How do you feel about it, right? Not what did it do. We don't have a lot of good, what I would call quantitative research, like how did it actually impact what happened. We do have some qualitative research. So the National Center for State Courts put out a study on remote courts that said 88% of respondents had home internet access, 95% of respondents had access to a cell phone. Only 1% had no internet access or cell phone. That sounds pretty good. However, access is not comfort. Access is not confidence, and only 66% of respondents said they were comfortable with video technology. 14% said they were a little comfortable, and a full 1 out of 5 said they were not comfortable with video technology at all. Now let's zoom out. Who are the respondents when this survey was distributed digitally, right? So this doesn't really get it. I mean, right? Where like, I hate to be a survey design person for a moment, but my key in this question was, who are the respondents in this survey? Because that first part looks good, but we know that that actually does not reflect America, and it certainly doesn't reflect poor America. While 52% of individuals said they would use a remote court option, those numbers fluctuated significantly when you asked them, would you use it for this or for that, like particular types of proceedings. Only 27% of respondents said they would ever want to use it in a child custody case. Any kind of proceeding in a child custody case, very few people want to use it. 64% of respondents would want to use it in a virtual proceeding for traffic court. Now look at that number for a second, because I'm going to suggest to you that that has a lot to do with how big the proceeding has as a value to you. And what that means is that 64% of respondents who would want to use it for a traffic ticket probably, if required, could pay the traffic ticket. The value of that proceeding for them may not be as high. And I'm concerned that if you flip that, the 36% who say we wouldn't want to use it even for a traffic ticket may be the people for whom that monetary amount is particularly valuable. Same thing, right? Everybody values their kiss. And I think that's why we maybe want to be seeing it. So where do we go for guidance on remote courts? I want to say, right, everybody is like, I know you're all here, I'm preaching to the choir, but the ABA is such a good source on this stuff. And in fact, they moved very quickly. I'm very proud of SCLAID. I was actually on staff when this happened. By August 2020, we had a policy on virtual court proceedings. It remains the policy of the ABA today. It supports a considered and measured approach in adopting and utilizing virtual or remote court proceedings. That sounds very vague, but I think it correctly conveys better than nothing. Don't close the courts, but a little bit of hesitancy. And it reflected, I think, at the time, the reality of the pandemic and the unknown impact of virtual court. So what does that policy say? And I think this is still good guidance for jurisdictions. I hope people are still looking at this. Mandatory use only when absolutely necessary, right? In a public health emergency where you really can't gather as a group of 10, okay. Mandatory use ends as soon as possible, and I would suggest to you that if we can all be here today, that time has probably passed. Permissive use to be governed by the concept of consent. This is consistent with due process, right? You have a right to counsel. You can waive it and defend yourself if you want to. If you want to knowingly and voluntarily waive your right to appear in person and appear remotely, I don't think anyone has a problem with that. And this acknowledges the myriad of situations and permutations that might impact ability to effectively attend a virtual proceeding. So if you're not good on camera, you're worried about this, you can go in person. But if appearing virtually helps you because you don't need to find childcare or transportation, or you're very remote from the court in which you have to appear, that's your personal factor to balance. And I think the single most important thing about the ABA policy is that it recognizes that the individual involved, the litigant, the defendant, along with their lawyer, is generally best positioned to weigh all those issues. Not the court, not a carte blanche rule. So whether you can effectively appear, largely up to you. Things that should happen in order to facilitate the use of virtual courts. If courts want to go virtual, then let's make it easier and better and more appealing and less scary. And let's also study it and make sure it's not having negative impacts. So things we can do, the participation should be free. That sounds crazy, I know. But if you don't have a cell phone, maybe you don't have to get a cell phone. Maybe there are places you can go to virtual court. Participation options, and by this I mean a lot of public defender offices now where there's still virtual court, their clients are coming to their office and doing virtual court next to their attorney. That's an option, right? And hopefully it's one we can perpetuate and then provide necessary supports. I think it's crazy if you're training your judges in how to use Zoom, you need to kind of make that accessible beyond the court. There should be tutorials available on how best to use Zoom and what Zoom court is going to look like. I can't tell you. So when I train young public defenders, the single most important thing to remind them of, and I think it's important for all young lawyers, you may have now done this 5, 10, 15, 20 times. For your client, it's almost always the first time. They don't know what's happening. They don't know in what order. They don't know who's going to be there. I remember when I was in a class, childbirth class, sorry, all the men. I remember one of the most important things they did with us was say, okay, we're going to have someone lie down in the middle of the room. If you have to have a C-section, here's who's going to be in the room, and we're going to show you so it's not scary. Because there's the anesthesiologist, there's the doctor who's doing the C-section, there's a surgical nurse, there's a nurse for the baby, there's, the anesthesiological nurse. There are like 18 people in that room. And if you don't know that, at the moment you go from planning your birth plan, right, with the soft music, right, and then all of a sudden they're like, no, sorry, you are having a C-section, and you end up in a room of 18 people, you're going to start panicking, and it's going to have a negative impact on that process. So they walk you through it first, so that when you see those 18 people, you go, aha, those people, that's the pediatrician and the pediatric nurse, and the anesthesiologist is over here, and you know who they are, or you have a rough sense that this is all normal. That is a huge part of our job as lawyers, to normalize this process, to explain it to our clients, to walk them through it so they know where they are and where they're going. And we need to do that better for Zoom court. We haven't done it well yet. And then we got to use procedures that reduce the possibility of prejudice. And I know that's hard, but I really love observing Zoom court where a judge says, can you move your camera into better light? Can you come closer to your camera, right? There are prompts that you as lawyers can do, that judges can do, that can make this better, and we should be doing them. And finally, provide contingencies for possible technological problems or access. If someone joins and the connection drops, we should not be issuing failure to appear warrants. That person tried, but it happens all the time. And guarantee that participants are not pressured or obligated to waive constitutional rights, including the right to an in-person proceeding, right? So if you're on Zoom court, you should not have to waive your right to appeal the validity of the proceeding. If something goes a little haywire in that courtroom, you should still have the right to challenge it. You know, someone IDs you on Zoom and you want to challenge the identification, that should still be valid. Takeaways on virtual court fairness, because let's be honest, right? People want this to stay. I was so impacted yesterday. I want to repeat this quote. I wrote it down. I scrawled it down in my own handwriting like a 4-year-old. Civil rights are cheap. When they cost too much politically or economically, they float untethered to authentic remedies that could lend real weight to them. And I have to say, as someone who has spent my entire career in public defense is a constitutional right that costs a heck of a lot of money. It makes it one that is very difficult to make sure gets done well. And virtual courts are a way to make it even more efficient and less expensive, and that scares the bejesus out of me. So we really need to pay attention to maximize the use of virtual courts. They have to be accessible. There is no one size fits all. The focus should be on access to quality counsel and those core principles of due process and fairness of the proceeding. Litigants with their lawyers are absolutely in the best position to determine whether they can competently and effectively appear online. They should be making those decisions, which shouldn't be a paternalistic regime. And in making rules, please, if your court is engaged in a rulemaking process about virtual proceedings, and many of them are, encourage those court committees to include the client community, right? To include lawyers from different types of practice, civil lawyers, criminal lawyers, prosecutors, defenders. Everybody needs to be at the table so that everybody's concerns are voiced. And that is where I am going to leave it. Tamara?
Awesome. Thank you, Malia. Well, I think that's a great outline of our foundation, and I want us to jump back into the nuance here, but I do want to be cognizant of the balance of our time. We have about 15 minutes left. So I do want to pose a question to our panel and then open it up to our audience. So I'm going to say this is our lightning round, which is probably totally unfair because my question is absolutely a huge one to give you all. So I apologize in advance, but I'm confident you can do it. So my question to you all is, so we have talked about some absolutely huge problems that the pandemic highlighted for us, some of which we knew were there, but maybe some of which we learned more about. So from your perspective, where do we go here? From here, what are some tangible solutions we can build on for the future? And I'm particularly interested in how you all feel we can focus on lifting up some of our more vulnerable populations, and also looking into the audience. We have a lot of young lawyers and law students. So where are some spaces that they can carve out to be part of the solution? So lightning round, what are your thoughts? Steve, I'll turn to you first.
Yeah, and that obviously with what you've heard from all three of us today, that's such a hard question to like pinpoint. I'll tell you today, I'm still dealing with COVID-related issues and where we go from here. Obviously, in the school context, I saw things just as a parent in a district that's, overall pretty affluent. It does have that Title I 40+ 90+%, but overall, a lot of those kids were learning to the best they could through remote. But we did see a lot in my representation in my own children's school district and others that whether there's a pandemic or not, there's some things that need to be fixed. I still think the access to internet in the school context is probably the biggest thing, and it goes beyond that in the municipal entity. I just don't know how 3 years out now, almost 3 years, we still don't have consistent internet connection for the children. I can't understand why the equipment for the children in a state educational system, we have 50 educational systems essentially operating in different manners, different expectations, and the devices the children are receiving to bring home with them now has increased, but they're still not equal. And so I still see some inequities on that end. So from the educational standpoint, I think there's things we can do to improve that. Teaching, there's a huge shortage in teaching, bus drivers, staff, paraprofessionals. So I think we're going to have to tackle that. If I was a young person now going through college, it seems like you got a lot of opportunities. Young lawyers, I think, also have a lot of great opportunities.
Wonderful. Wendy, Malia, who wants to go first?
Well, every time someone talks about disasters, I'm reminded of after 9/11, we put together huge amounts of money, billions of dollars in grants and training. What do we get for all that money? People made a career out of it briefly, and then they moved on to something else, and nobody else followed up. So I think one key here is not to distinguish disaster planning and response from everyday planning and response in the law. And another thing that I've seen is, I think, picking up entirely on what Steve said, being able to, and what Malia said, Malia, get everybody in the room. Everybody has an important perspective that if you focus on just your part of the law, you will miss, and you will miss opportunities. I've seen that in people putting together model laws for disasters and creating volunteers for states to come in. They focus very carefully on eliminating liability for people who go in. That was not the problem. The problem was they needed people trained to help. They needed resources in line. But lawyers who were interested in this project only knew about liability issues. They didn't understand that the resources were the issues at hand. It can be more complicated. It doesn't sound quite as legal, but actually there are multiple ways in which lawyers can help create the resources that one needs. But again, try not to make too hard a line between disasters and normal needs, and make sure you get everybody's perspective before you start looking at a particular solution.
Great. Thank you. Malia?
I'll echo some of what was said yesterday about the need for pro bono assistance. I mean, first of all, if there, Houston, Texas, Harris County had not yet dug out of its criminal backlog from court closures from the flooding when this hit. They were at a 4-year backlog in homicide cases at the time the COVID pandemic started, right? Across the country, the backlog, particularly of high-end criminal cases, is astounding. As a profession, I think we're going to have to confront that. There is a massive need for lawyers. If you Google public defender or district attorney shortage right now, the number of articles you will pull up is astronomical. I would be sorely remiss if I didn't say that sitting in Oregon, where ABA Slade put out a workload study that said they have 1/3 of the public defenders they need in this state. We as a profession really need to look at that. It is hard work. It is challenging work, I think, particularly post-pandemic, because it is in-person work. We need to look at incentives to get people to go into areas of law most impacted. that can really help dig out and can really create the infrastructure we need for a justice system that's effective moving forward.
Awesome. I think we have time for 2 to 3 questions. We have a mic here, and I think Allie had one in her hand. Do we have any questions from folks in the audience? Lynette, yes.
Hi, I don't really have a question, but more like comments. And when we're talking about the pandemic, Potpourri, also like considering the law student perspective of how like not just barriers of the problems that we were faced with, but also like there are a lot of benefits that a lot of people don't realize for underrepresented communities and when we're mentioning inequalities. With having virtual opportunities in law school, it makes law school more cost effective for many of us. And then we're also better able to get opportunities. Like for instance, I attend law school in Louisiana. But because of the pandemic, I've been able to attend virtual internships across the nation, or even work or go to school while at home, which means it's more cost effective. I'm not paying for relocation. We're now having ebooks and not having to purchase other types of books, which is much more costly. So I'm saying all of this because I know that we mentioned things like the boxes is not more personable, but those boxes are sometimes because underrepresented communities can't show what's in the background, or they have their kids and the audio needs to go off. Mm-hmm. So really think about the full spectrum when we're considering education and the opportunities that we could provide for others. You're also giving access to diverse faculty and admin when you allow them to zoom in from other areas to teach us. So we might get better quality of professors and education while we're in law school. So don't be surprised if the Law Student Division at Annual presents a resolution that has something to do where we're opening doors and access and lowering costs by way of virtual or hybrid opportunities in law school. I understand that there's a lot of opposition when it comes to ABA, just from the conversations that I had, probably because you've gone through different paths. But I'd really like to talk to people who might be interested in looking for innovative ways to reduce cost to education and law school entrance exams because it's virtual or hybrid.
I think that's a great point. Thank you. Yes.
Good morning, afternoon. I'm the hybrid commenter. I wanted to note that while we focused on the pandemic, we have a disaster right now happening live on the southeast coast, from Florida. It's now up to West Virginia, and which is where I have a house. I'm not happy about that news. But in any event, it's going up to Maryland. The entire East Coast is devastated. Those kids, when you look at the infrastructure pictures on, what infrastructure you say, on TV for Ivan, there are no schools, there's no power grid, so there's no remote learning. Those kids are going to be as behind as the pandemic kids. So pandemic should not be defined narrowly. It should be defined as a disaster expansively. I loved what you said earlier about we need to think about planning, but disaster planning is a subset of planning. Thank you very much. You folks are splendid. I'm Beverly McQuarrie Smith, and I'm also a hybrid liver because I'm fully retired. So you could find me on the East Coast or the Gulf Coast. Thank you for your attention.
The state and local government section claims her, so nobody else can have her.
Thank you. Anyone else? Questions, comments?
They're all hungry.
4 more minutes until to lunch. So other than that, it's an impromptu comedy show by the panel.
Right.
So.
Does anybody have a quick, unique story? Oh, here we have the Attorney General here.
At the risk of overdoing Oregon, because you can learn a lot from Oregon, but we can also learn a lot from you. And I want to thank you, Malia, for that study. It's an embarrassment to our state, but it's really important to have it. And frankly, it wasn't going to get done internally. It needed to be, and it was requested by our legislature.
Yes,
so I want that to be noted.
Yes.
But I also wanted to kind of echo that there are some silver linings to the pandemic. And one is actually our legislature. Up until the last couple of years. You had to drive, if you were, if you lived in Eastern Oregon or Southern Oregon, you had to drive to Salem to testify on a bill for 5 minutes, right? There's time limits. Now, and probably for the foreseeable future, maybe even forever, we are going to at least have hybrid hearings, legislative hearings. And so not only is it an opportunity to participate in democracy and to actually have your voice heard, but it's a way to learn. And so I wanted to point that out because a lot of you are, not quite sure where you're headed with your careers yet. Some of our summer clerks, I used to feel, initially I felt sorry for them because they couldn't come to the office. And like, no, you don't understand. We can watch the court hearings online. We are learning so much by being able to actually observe what's going on. So there's another, silver lining, both with regard to the courts and the legislature. So I kind of wanted to chime in on what our wonderful, law student leader, right? She's like the head of the law student division. Did I get that right? Woo! That's great. Anyway, thank you.
Awesome, thank you. And thank you for being with us and with all of your support during this conference. It's been great. Any other questions or comments before we wrap up? Okay. Well, I want to just take a moment to thank our panelists for your perspective and for your expertise and for being in the trenches. You all have had great contributions to the profession and to society during a very hard time. So thank you, Malia, Wendy, Steve. I appreciate y'all and for all of the emails. Appreciate you for being here.
Thank you for putting this together.
Yeah.
Yes. I encourage all of y'all to access your program materials. Our panelists put together some great resources for y'all, as well as your slides and your outlines, so please feel free to access them. And thank you for attending the program between break and lunch, so we appreciate your time for that. We hope that y'all got some pieces or nuggets of information that inform the information you take back home, but also provide you some empowerment to protect those who are most vulnerable, but also, kind of to harken back to Steve's comment, to inform the book that we hope to write to protect society when we go into the next emergency, which we all know to be inevitable. So with that, have a great lunch. We thank you, and we'll see you when we socialize at lunch.